Hello, everyone, and welcome to the National Inventor Club. We are in March 2026, and as always, we bring amazing guests to you to help you keep moving your invention ideas, your businesses, your startups moving forward. And we have a great lineup tonight. We have Matthias Reischle-Park. He is coming in from overseas representing the WIPO PCT, which stands for World International Patent Organization. I think that's right. And if it's wrong, he'll correct me. But look, we come up with our ideas. We want to protect it. We want to make sure that we can sell overseas, or maybe we want to get patents overseas, international, and representing different countries and protecting ourselves. So we're going to find out about how to do that. And I'm going to pick his brain for you. I also have several guest intros that always come on and do an amazing intro of different tips and tricks and advice to help you keep your ideas moving forward. So let's start off with Bob Harrison. He is from Stony Brook Small Business Development Center, which is a division of the SBA. Bob and I have met many, many years ago when I used to do inventor clubs in Long Island, and Bob is here tonight representing Stony Brook Small Business Development Center. Bob, welcome to National Inventor Club for the first time. And if you don't mind just giving us a quick intro about yourself and then share some tips and advice for us.
Oh, very good, Brian. Thank you. Yeah, I've had an interesting career path, been primarily in manufacturing businesses out in commerce pretty much since 1978. Different companies, technology companies, settled into a career industry, was able to operate my own startup business for 8 years and sold that and ended up going back to Stony Brook at age 60 for my MBA. Came in contact with the Small Business Administration SBDC office at Stony Brook University just over 8 years ago. I joined it part-time and have eventually worked it full-time. So I share a lot of the industry experience, startup experience, how to obtain resources, build a company. It's been a great journey, and I share that with the clients that come to us. And if you're not an overview of the Small Business Development Centers, it's a nationwide organization, as Brian mentioned, part of the Small Business Administration. And SBDC offices are staff with people usually on university campuses across the country. So we have 22 locations in New York State, and on Long Island we have offices in both Farmingdale and Stony Brook. We tend to cover, Suffolk County mostly, and we get all sorts of different people coming to us. It can be just a business idea, or it can be a company that's somewhat established, wants to grow. They're looking for funding for business plans, financing. And what we try and do is to be a resource for them, to vector them to what's going to help them. I typically will help people that are looking for government grants, like the Small Business Innovation Research Grant. If they've got a consumer product invention and they don't know where to go, I'll send them Brian's way. To help them kind of navigate what they need to do with their product. Do they need to protect it initially? That's going to be one of the topics tonight. Are they going to want to need a contract manufacturer? Are they going to need like some prototyping done? So I try and connect them with resources at the university, which are many. And when I had my company, I really was not aware of what the university and the SBDC, how it connects to university resource. We've got several organizations on campus, like the Long Island Manufacturing Extension Partnership, that helps manufacturers offset maybe some consulting agreements for lean manufacturing. We've got academic resources with the College of Business and also College of Engineering. And so over time, I know I become more valuable because I tend to meet people and network, and I can refer them, do introductions. It might be to the Long Island Angel Network. It might be to resource somebody, maybe their credit score is not as good as they like, but they They have a great idea. They have a purchase order. They want to get started. Oh, how do I fund this? I can't do it myself. So we'll usually have an initial consult. Everything is confidential and no charge. And we'll try and locate them. And I like to do like a past, present, future. Where have you been? Are you working full time? You're starting a side gig. Where are you now? Where do you want to go? And then based on that, I kind of get a good picture, and we'll try and assist them, get them in connection with people, resources that are going to help their business propel forward.
Thank you very much. And one of the things you might have missed there is there's no charge. So SBDC stands for Small Business Development Center. They are nationwide. You could go to America's SBDC to find a local office near you. Most likely they're in one of the campuses that are right by you. So if you're looking for business plan help, if you're looking for, like what Bob mentioned, you're looking for government grants, you're looking for local resources. He mentioned a few for Long Island, but in the areas that you're in, they also have similar type of resources. And again, it's free. You must take advantage of these type of opportunities, and you can find it at America's SBDC. Bob, we appreciate having you on. We look forward to seeing you more, and keep helping us out. You're one of the advisors there in this campus, and the way that you presented yourself tonight, that's what people can expect in the other campuses around the country. So thank you for doing what you do. I know during COVID, your team was very busy and supporting the small businesses, entrepreneurs. So we appreciate you. And please tell Willa we said hello as well.
Very good. Thank you, Brian.
Thank you. We'll see you again soon.
Thank you.
Okay. All right. Let's put up Sarah Bonzo.
Hey, Brian.
Hi. How you doing, Sarah?
I'm doing great. Glad to be here.
So Sarah is my former professor. I'm in the middle of taking my master's. I'm almost done. And I have to say that, and I'm not saying it just because you're on here right now, but it's my favorite class. It was called Design Thinking. And Sarah is the chairperson, and she's also a professor of the marketing and the business department. And let me tell you something. If you haven't heard about design thinking, you need to look into it. It completely opened my mind. You come up with an idea and you think like, oh my gosh, everybody in the world wants it because that's how I feel. Well, there's more than that. So Sarah, thank you for joining us. Please give us some advice to help the inventors, whatever stage they're at. But if you catch them in the beginning, that's probably where you want to catch them, right?
Yeah, absolutely. And so design thinking, if you want to learn more about it, I've got just a couple quick slides here to talk through. Design thinking is all about designing with, not for somebody. So it's semantics, but it's a really, really important distinction, because oftentimes when we have that light bulb moment where we're like, oh, I've got something, right? What we do is we get laser focus and we go after this thing really hard. And in any incubator or accelerator program, customer discovery is going to be a huge part of that. And design thinking really takes us through innovation, starting with the customer or the user first. So this is the general framework used for design thinking. And I will say, if you have interest in this, tons of great books. There's a lot of information for free. The IDEO organization that's run through Stanford has a workbook online, totally free, tons of great examples and worksheets to work through there. We start with empathizing our user or our customer. How do we empathize with them? One of the lean techniques we can use, for those of you who are familiar with lean manufacturing concepts, is going to Gemba, the Japanese term that means a real place. How do we actually go and sit with our customers, our users, understand the challenges that they face firsthand? Because oftentimes we're a little bit further removed and we see something, we have a different perspective, but it's really important that we sit with and talk with and experience whatever they experience. So that is a really important distinction, something to do up front. And you don't necessarily just have to do it up front. It's really important to do up front, but you want to do that through your entire innovation journey. How can you continuously find ways to go and talk with the people that you are actually designing for? And when you do that, you in turn design with them. So once we really get an opportunity to talk with, interview a number of people, and what I will say here is one of the key differences in when we go and start talking to folks is that we don't want to pitch them or sell them on our idea. We want to withhold that, right? It's not about validation of your idea. It's really about understanding what problems do they experience, right? Don't even put your idea aside and just ask them about their experience, right? What challenges do they run into? How do they address those challenges? What workarounds do they create? Because there's gold in those answers, and that might meaningfully shift you and pivot you in a different direction. And so getting as many of those insights up front will absolutely help you on your journey. So doing that and really empathizing, then that helps you define the problem more specifically. And I will say that with all of my MBA students, and I have students with a variety of backgrounds working in a variety of different industries, new products and services, entrepreneurs, is that so often, because we have an idea in mind, we jump to that solution, right? We're like, all right, I got something, I'm going to go for it. How do I build it out? How do I get protection? How do I start prototyping without first defining that problem? So we want to get as super specific and explicit about the problem we're trying to solve for our users. And then that takes us into ideation, where we want to consider a lot of ideas, crazy ones, realistic ones, ones that aren't realistic. And we want to get them all up there, because again, so often when we have an idea, is there something called anchor bias. That first brilliant idea that we have, it's like our baby, right? We hold on to it. And it's really hard then to start thinking about, all right, well, am I solving the right problem? Are there other solutions that could, address this issue better for our users or our clients? So we want to be kind of divergent, think about a lot of different ideas, and then we want to prototype as early and often as possible. One of the things we do in our classes, we talk about low fidelity prototypes. How do you create, and there's a lot of terms for this. You could call it minimum viable product, but how can you get the scrappiest version of something out there for people to give you feedback on? And then we test and iterate. So that's the general framework. And it coincides also, if you're familiar or have heard of lean startup. So this is called the double diamond process. And again, it really, I think it supplements, complements design thinking, because as we think about kind of this framework, and this is utilized a lot in software design and development, is that you want to stay really open. You want to think very divergently about the problem set first, and then define, converge on that right problem. And then we want to think divergently, again, thinking through all the different ways we could solve it, and then getting some feedback and converging on one that we really want to prototype with. So I would say in all of this, one of the key takeaways with design thinking is really understanding your users and customers, whether you call it design thinking, empathizing, doing interviews, going to Gemba, customer discovery. That is at the core, because there are so many aha moments that you will have, just sitting and talking with somebody. And again, those little shifts are so important in thinking about, are we solving the right problem? And so there's a couple ways this can go. If you're already on your journey and you really start then diving into customer discovery and talking to folks, you might find that, it shifts how you're thinking about what the real problem is. Or you might find that there's another market that you hadn't considered that is actually a lot bigger than the one you had initially thought of. So, hopefully, Brian, I can come back on and do a deeper dive, and we can continue talking about this. But I am
Definitely.
I'm happy to talk with anybody at any time who wants to talk more about this, and I'm happy to share resources as well.
Thank you. And take your class.
Yes, we are the top ranked online MBA program within the SUNY system. If you have any interest, if you're thinking about an MBA in your journey, please reach out. I'd be happy to talk to you.
Thank you very much. And I have some wisecrackers texting me. I did get an A in your class, I believe, right?
Yes.
Okay.
And it was so great that now we are bringing Brian on to teach in our entrepreneurship program starting next year. So we were very excited to have him with us.
Thank you so much. Sarah, thank you. I know you just flew in from Florida. We appreciate you. Thank you for joining us and sharing your knowledge and wisdom. And we need to do a whole session with you. So we'll see you again very soon.
Sounds great.
Thank you. See you. Thank you. All right. Let's bring up. You may not necessarily. Uh-oh. I think we have some feedback. David, can you lower your mic? I'll come back to you in just a moment. Okay, let's try. Here we go. Elizabeth Doherty. Elizabeth, how are you?
Brian, I am fantastic.
We don't hear you.
Oh, no.
Let's make sure your mic is working.
I've turned it on.
Testing. Uh-oh.
Oh, no. That's so weird.
Oh, we don't hear you. Just check on your microphone. Just make sure that you pick the correct mic. Let me try David one more time. I'll come right back. David.
Yes.
Uh-oh, I hear an echo.
I hear an echo.
I'm going to let you talk.
I'm going to let you talk.
Introduce yourself and tell us
who you are.
and a tip
Hi.
and advice for us.
A tip and advice for us.
My name is David Klein. I'm the inventor of Jelly Belly jelly beans. In 1976, I had $800 to my name. No credit cards back then. I found an ice cream parlor and I said, I'd like to have the corner of your place to sell my beans. I'll give you $1 a pound because I don't have rent. And about a year and a half later, he became a distributor of mine, and he filed for the state trademark behind my back, the state of California. We had filed a federal trademark, and our attorney told us, don't bother to file a state trademark because the federal is the most important thing. And so we listened to our attorney, and he called me up one day. He said, I own the California trademark, and I am your new partner. So it caused a tremendous amount of problems. We also had a problem with our distributor in Canada who filed for the Canadian trademark for Jelly Belly. And that took a lot of getting out of. So we've had considerable problems along the way. We were forced out of the business in 4 years. We were told that if we didn't sell the trademark, they would start making the product for themselves. They knew we would sue them, but by the time it got to court, we would be broke. And so without an attorney present, we signed away the trademark for a 20-year period. First of all, if you're selling something for millions of dollars, have an attorney with you. Don't do anything without an attorney. So we sold the trademark back to the company that was our contract manufacturer, and we could not compete with them for 20 years, which was a crazy amount of time, which could have never have been held up by any court of law. They might have held up 5-year period, maybe 10, but certainly not 20. So I could not compete with them for 20 years. And that's my story.
You know what? I just put him on mute so we wouldn't hear the echo. But as soon as I finish talking, I'm going to put you back on. So David has an amazing book. Oh, I left it upstairs. It's called It's Time to Spill the Beans. He also has a movie that's on Amazon and it's free on YouTube. So Amazon Prime, and it's free on YouTube, and it's called The Candyman. He gave you a little taste of, no pun intended, of Jelly Belly beans, of a little bit of his story, but it is unbelievable. It has some twists and turns in there that you'll be surprised to hear. But here's David Klein. I've been friends with him for many years. He's also been a fan of National Inventor Club. He comes into the Inventor Smart Community app. You can find him in there. We do different events, and David's always very kind and supportive to share his story. And I know he particularly brought that part up because we have WIPO, international patents and protecting yourself overseas. So David, thank you for joining us, and we will see you again very soon. If you can unmute yourself and say goodbye to everybody, that would be great.
I don't know how to unmute myself.
I did it for you.
Okay, thank you. It's been a pleasure. Good luck to everybody. You guys are great, all of you. Thank you
so much, David.
Thank you so much, David.
All right, let's get Elizabeth Doherty back up. I heard that you all heard her, but for some reason I wasn't hearing her. So let's get Elizabeth. Elizabeth?
Well, Brian, can you hear me now?
Yes, perfect.
Oh,
I think
fantastic.
everybody.
Oh, I'm so relieved.
Excellent. So Elizabeth is from the U.S. Patent and Trademark Office. She has several titles. She is regional director of the outreach and of many states. Well, she'll explain to you. But in the next couple, well, actually next week It's been a while since we've been saying that, but it's finally here. The National Inventor Club is being hosted by the U.S. Patent and Trademark Office. Elizabeth Doherty is putting this together with her colleagues to roll out the red carpet for us. We're excited. Many of us are going to Alexandria, Virginia. Some of us are joining March 25th, Wednesday evening. We're going to have a social mixer there where we're hanging out from 7 to 10 p.m. at one of the restaurants. And then March 26th, we have a full agenda, which Elizabeth has kindly put together for our inventors. And we still have a few spots open. If you would like to find out more information, you can go to inventorday.com. I put a little landing page up there, and there's a registration, and you'll get more information once you sign up. But there's a video that we have and some other information, and hotels and transportation. If you happen to be near Alexandria, Virginia, it's a hop, skip, and away. If you want to fly, there's still some flight deals out there. Hopefully you'll find that gas is on a daily basis going up and down, but maybe you can find yourself a good flight. And we'd love to have you join us. You're watching us tonight. Sign up and we'll see you in person live, and you'll see Elizabeth and I next week. So Elizabeth, a little bit of a long intro there, but thank you so much for doing what you do. And if you want to say something about next week, but also we'd love to hear how you can educate and inspire the other inventors, entrepreneurs, and startups that are joining us tonight.
Well, Brian, thank you. And it's always a pleasure to be on with you and your team and your remarkable speakers. Oh my gosh, I've learned so much from the first 3 speakers that have preceded me. I want to take Sarah's class, and I want to read the Candyman's book. And of course, our friends at the SBDC, we couldn't thrive without them. I am a firm believer in the power of the Small Business Administration and what they bring to America's entrepreneurs. Well, Brian, happy Women's History Month. I hope everyone takes a moment to give a word of praise and a word of thought to some of the fabulous women inventors who have populated our patent rolls. Whether your favorite is Beulah Louise Henry, Lady Edison, whether it's Ellen Ochoa, Stephanie Kwolek, Hedy Lamarr, I hope that everyone takes a minute to thank a woman inventor, because there's a lot of them, but not enough of them. I'm also super excited for your guest tonight, Matthias, because next month, April, we're going to be celebrating World IP Day, April 26th, which commemorates when the beginning of the World Intellectual Property began in 1970. And this year's theme is super fun. We can all celebrate it. It is IP and sports, ready, set, innovate. So I think as we transition to April here in the not too distant future, we're all going to get to celebrate IP in a very fun way. But let's talk about what's super important. And I can't believe it, Brian, it's right around the corner. Inventor Day at the U.S. Patent and Trademark Office, our collaboration with the National Inventors Club. And Brian, I love the fact that in your background, you have a poster from a previous Inventors Day at the U.S. Patent and Trademark Office that we also fondly signed at the end of our experience together. As you've already teased, we do have a full day of education, information, demystification happening on March 26th at our Alexandria, Virginia headquarters. It is going to be a soup to nuts day talking about USPTO history. How do you as an inventor fit in the world of invention? We're going to talk about patents. We're going to talk about trademarks. We're going to hear from a variety of our business units, bringing people up to speed on some of our new initiatives and programs. And we're going to have a time to interact and to network to one another. We know the power of networking. We see it each and every month here at the National Inventors Club. So that's certainly going to be a key piece as well. Brian, we're so awe-inspired and so grateful that you want to bring your organization to the U.S. Patent and Trademark Office. So we are so incredibly pleased and proud to host you on March 26th. And of course, with a little opening reception on the 25th. So I hope we're going to see all of your members there. And as you said, there's a few spots still available, but I know they're going fast.
Thank you so much, Elizabeth. We get to see you again next week for those of us who are able to attend. If not, I have to say that between Elizabeth and her colleagues. They are very strong advocates of providing information to us on our platform here with National Inventor Club. And you can go back into the archives and see Elizabeth present and her other colleagues on patents, trademarks. We've had the Copyright Office on, but there's a wealth of information in our archives that the U.S. Patent and Trademark Office has been very active providing content and information to us. So thank you again for doing what you do, Elizabeth, and we will see you next week.
I'm looking forward to it, Brian.
Thank
I
you.
can't wait to see you on campus. Thanks so much
Thank
for
you
having
again.
me this evening.
See you soon. Okay, bye-bye. All right, and let's have Matthias Reischle-Park. He is from, what country are you in tonight?
I'm actually from Switzerland, or actually not from Switzerland, or originally from Germany, but I'm living in Switzerland because WIPO is headquartered in Switzerland. And so I'm a little bit on a night shift tonight. It's
What
starting
time
to
is
be
it?
nice and quiet. It's kind of like 1:30, no, 12:30 here. So
12:30?
thanks. Yeah, it's not too bad. So I'm totally excited to be with you all.
Well, thank you very much. I know we had a few technical difficulties here, but in this day and age, we have multiple options to make it happen. So we are happy that you're joining us all the way from Switzerland. You are the
Wonderful.
deputy director of
Mhm.
WIPO, and you might hear these terms, WIPO, PCT. When we file here in the US, we have a chance to protect our intellectual property in other countries. And the way
Mhm.
to do that is through WIPO PCT. And WIPO stands for World International Patent Organization. Is that correct?
World Intellectual Property
Intellectual
Organization,
Property
because
Organization.
we
Okay,
don't only do patents, we also do trademarks and designs and stuff. So yes, it's all types of intellectual property.
perfect. And then PCT. What does PCT stand for?
Yeah, there are some evil souls that say it stands for pretty complicated treaty, but that's of course not at all true. It stands for the Patent Corporation Treaty.
Patent Corporation Treaty.
Yeah.
Okay.
Mhm.
So,
Mhm.
Matthias, we've had a chance to get to know each other prior to joining here tonight and your morning. And look,
Mhm.
we're inventors that we look for information, we go to different sources, and we try to find what's right. And one thing that I'm really proud of is when I have enough inventors that ask me the same question, I bring the right resource, which is directly from you to give that information.
Cool.
So
Yeah.
we're at a point where, let's say, we filed a patent. Um, maybe we want to manufacture overseas. Maybe we want to make
Mhm.
sure that other companies don't infringe on our intellectual property that we can kind of made here in other countries. And along the way, we also want to know that if somebody does infringe, that we have some way of kind of protecting ourselves.
Mhm.
So I'd love to pick your brain tonight. I've gotten emails and requests from inventors on questions. I'm opening up the Q&A here also with the comments. You're more than welcome to put your comments in, and we can ask Matthias along the way. But let's start off by maybe hearing a little bit formally what you do at WIPO PCT and a little bit
Mhm.
about the WIPO PCT.
Yeah, thank you very much, Brian. So the PCT really is sort of the biggest part of WIPO and one of our most successful treaties that we're administering. I would say we're a bit like the secretariat for this international treaty, and we are kind of in charge to making sure that the cooperation between the various partners involved in the PCT works smoothly. We look at further developing the PCT system to maybe add some additional safeguards. And over the years, many safeguards have been added to the PCT system. But we're also basically servicing applicants and inventors. If they have any particular question, they can always turn to us. We have dedicated help desks in Geneva. Admittedly, it's our local time, but you can always drop us an email and reach out to us. So I guess inventors have the resources available on their kind of national level. There's a PCT help desk also at the USPTO. But if they all would like to get in touch with WIPO itself and the colleagues from the PCT, they could also reach out to us.
Fantastic. And you've been with WIPO PCT for how long?
Yeah, I've been with the PCT actually for quite some time. I think it's now 25 years. So I'm part of the furniture, as they say here. But it's been a really good journey. When I started with the PCT, I was a little bit worried. It's kind of a narrow field. It would maybe become boring. But actually, throughout my career, it turned out to be a super interesting job, and I really love it. I'm deeply into sharing knowledge about the PCT and helping applicants see the benefit of the PCT, or helping out if they have any kind of an issue. And since we're kind of not that big a group of PCT experts, you're very quickly at the very forefront of all the most recent developments in the PCT system, and that really makes it very exciting for us.
Excellent. So just a couple questions, which we're going to answer along the way. I know that you put a couple slides together, but
Yeah.
here you go. How soon after we're granted a USA patent can we still file for an international patent? Have a US patent need to file abroad by August? So he seems to know when he needs to file. And it looks like there's a couple more here, but several of the same, but we'll get to it.
Okay.
Be good. So let's pull this up.
Yeah.
And
Actually, can you maybe move to slide number 6? That would actually probably give a good
absolutely
overview of the PCT system, and I can start talking about that.
perfect.
So I guess if you are an inventor or a small company with inventions, I mean, you do need to worry about, do I want to protect them? I mean, obviously, the alternative to protecting would be keeping it as a secret, a trade secret, but that's not always feasible depending on the invention that we're talking about. So if you start going down the route of looking for patent protection for your invention, most applicants will start out with a national application. So in the US, I guess a lot of you would file a provisional application rather than maybe a non-provisional. But let's say you file a provisional, and then the clock basically starts ticking, and that's super important. And one of the things, of course, everyone needs to be aware of, and not make a mistake in this regard. So the clock that ticks basically starts on the filing date of your initial national application. And then if you want to protect this same invention in other countries, you really need to take the next steps before the expiration of 12 months from the initial filing date. And that's
Okay.
called the priority period.
So Matthias,
Mhm.
you mentioned provisional patent
Yeah.
application. So that is a filing date, which gives us
Mhm.
the right for 1 year to say that we're patent pending while
Yeah.
we're exploring the market, whatever it is. Within that
Mhm.
1 year, we would file the non-provisional patent
Right.
application, otherwise known as a utility patent. And
Yeah.
then there's also design patents. So what you're saying is when you file, whether it's a provisional patent application or the non-provisional, is
Yeah.
when the clock starts of the time that I have to file an international patent.
Yeah, exactly. And basically there are two pathways to obtaining international patent protection. I'm a little biased, and I think the best thing to do is file a PCT application, but I have to be honest, there is also a traditional way of obtaining patent protection in other countries, and that is often referred to as the Paris Convention. So rather than filing a single international application, you, before the expiration of 12 months, you file multiple national applications, let's say in Japan, in China, in Korea, in Brazil, wherever you think you need protection depending on your business model. So that's the Paris Convention. And these subsequent applications under the Paris Convention, you also need to absolutely file within 12 months. Or alternatively, and that's the alternative I would like to talk most about tonight, is you file a PCT, a single international application, which covers all of our contracting states. And we have by now 158 contracting states. So really you cover the world with a PCT application, but you need to absolutely file the PCT within 12 months from your initial national application, because otherwise you can't claim what we call the right of priority.
And this goes for any of them, right? I know there's other types of patents, but whatever it is the start of it. So
Yes, yes. Hmm.
so here we are. We have a chance to file in other countries.
Hmm.
What would be kind of the thought process of what we should do? I mean, I don't know how many countries there are that you kind of cover with the World Intellectual Property Organization. But
Yeah.
how do we know, like, if we're manufacturing possibly in China, do we just do China? What if we want to sell in other countries? Maybe from your experience, seeing and hearing other
Mm.
startups, how do we make that selection?
Yeah, that's probably one of the most difficult things to decide for any applicant. And one of the difficulties is also that, your picture yourself might not so be clear at the outset and might only become clearer a couple of months or a year down the road, or even take longer for you to become perfectly clear. But what I guess most applicants need to think of, what do I want to do with the patent if I get a patent? I mean, do I want to work my own invention? That is, I want to manufacture this invention and sell it in a bunch of countries. Is that my business model? Or is my business model really restricted to one particular country, but I fear that maybe someone else could easily make the same product in another country and then import it into the market that I'm really interested in. So the place where, your competitors could make your invention, so to speak, and manufacture your invention might become a country that's very important for you to have a patent in, so you can actually stop them from doing it.
So
Another
yeah, go ahead.
Yeah, another thing to think of, maybe you're not really in a position to work your patent in various countries, but maybe you have an interest in licensing your invention to third parties, and so that they can actually pay you royalties, but then be entitled to use your invention in whichever way or shape. So that's another thought. And then, in order to really be effective in licensing an invention, you need to have basically patent protection in a particular country where you would like to sell your license effectively.
So if I was, and some of you have heard the term
Hmm.
licensing. So licensing means that you're finding a manufacturer that's in the space of your invention idea
Hmm.
that you came up with, and they're responsible for the manufacturing and distribution. And usually, you want to find a company that has really good distribution, so they can really do good volume, so you and them can do well together. So every time one of them sells, so they made it, they distribute it. Every time one of them sells, you would earn a royalty. So an interesting strategy, and there's many of them, but the way Matthias kind of mentioned here is, let's say you're patent pending, and one of the companies that's a player happens to be headquartered in another country, or the company in the US might have really great distribution overseas.
Mm.
And while you're patent pending, which is still within the year of being able to file international, they express interest, and you say, "Well, I still have a chance to file international. Perhaps we can add this as part of my assets of my intellectual property to kind of sweeten the deal." So you could do it that way, right?
Mm.
Or like you mentioned, if you're looking to manufacture to kind of protect yourself. So look, Matthias, if I invent a product and I manufacture it here in the US, if somebody happens to, let's say I work with a factory overseas, and they end
Mhm.
up making it and they start selling it in other countries, I can't really protect myself
That's
But
right. Yeah.
if they try to bring it back into the US, that's where I'm protected.
Yeah.
So my question to you is, I don't know this moment, maybe you can help if you have, not to put you on the spot, but the fees. If I say, I
Mm.
want the whole world
Yeah.
protected with my invention because everybody in the world should be using and want my invention,
Yeah.
or am I kind of picking some? And then what is that like to kind of figure out and how to file?
Yeah. Yeah. That's a very good question. And I've talked to a lot of inventors, and their initial reaction is, well, my invention could be used anywhere. I need protection everywhere. So it's understandable, but economically, it's probably not feasible. Even the big players out there, the Microsofts, et cetera, they don't have patents on their invention in each and every country. It's just simply too expensive. Uh, just the fees that you need to pay per country, and usually also they come with needing to hire a patent attorney to help you prosecute your application in the various countries. I mean, this is like easily between two and 10,000 US dollars per country. So it's just too expensive to try to protect your invention everywhere. And so I think what an inventor, what an entrepreneur needs to think of, where do I really absolutely need protection, and where would it really hurt me if I don't have protection in my business model, and where are the places where it would be nice to have protection, but my business is not going to completely depend on it. And so these are the ones I'm not going to go for, but I really then would focus on my places and countries where it would really hurt my business if I weren't protected there.
But many
And
of us, yeah, but
it's
many,
an evaluation you need to do, and
right. But in the beginning, like many of us just came up with our idea and we're happy
mm,
to pay all the fees that we need to with USPTO, US Patent and Trademark
yeah,
Office. And we should think about how we're going to do and protect ourselves overseas. And
yeah,
I could say that from my experience, I have 15 issued patents here in the US and a couple more
hmm,
pending, that other countries that tried to bring in product that I had, my invention, into the US, I've showed the resellers, the retailers, that I have an issued patent, and I
hmm,
was able to protect myself and take them right down. And the platforms did it for me.
yeah,
So I know that, let's say, if they're making them overseas and they're selling them all around, I can't really do anything much about them. But let's say, Matthias, that I had a
mm,
patent, let's say in China or India,
hmm,
and people start making it without my permission there. How do I protect myself? Do I count on
yeah,
you, Matthias, to take them down?
yeah.
Who do I call? What do I do?
Yeah, yeah. I wish you could, call upon us and we would offer this service. So we're really talking about enforceability of patent rights here in the various jurisdictions in the various countries under the national law of those countries. And essentially there you really need to get out there and hire a local patent attorney to help you enforce your patents. and
Okay.
and to be honest, I mean, it's one of the criteria that applicants around the world use in their decision where to get protection, is to look at the question, how easily enforceable is a patent in a certain country. It used to be very difficult in China, to be honest, but today it's much more doable and much more acceptable to try to do this as a non-Chinese. So it's something that should also flow into your consideration of where ultimately you need protection. But unfortunately, I have to say, the applicant or the inventor there is on his own, and he needs to then take the case, if worse comes to worse, to a local court, and try to stop the competitors from doing what they're doing.
That's tough for us. I mean,
Yeah.
I'm just curious because look, you're saying that we file and then we have to go there or we have to
Mhm.
call and get representation, which costs. And we don't
Yeah.
really know how much money. Well, we kind of get an idea of how they're selling or who they're selling
Mhm.
to make it, to see if it even makes sense that between airfares and representation and everything else, if it's costing more than somebody infringing on our intellectual property there. So
Yeah.
my question to you is, do you feel from your experience in watching the applications come through from the US, do you feel like it's
Mhm.
more corporations that are kind of protecting their patents and IP, or independent inventors, and maybe have some kind of percentage of how much you think inventors kind of represent?
I mean, behind every invention, there's an inventor. That's obvious.
True.
Well, I guess today with AI, maybe that's a bit more questionable than it used to be,
It's
but
just a
that's a
tool.
different topic. Uh, I, I mean, the PCT, I must admit, is predominantly used by big corporate applicants. I think there's no denying. If you look at our annual statistics of who files, the biggest filer today in the PCT system is Huawei Technologies from China, and you know the next biggest ones are all big corporate applicants. So the number of small inventors or kind of individual inventors, I mean, roughly speaking, I think is more around like 5% of all the applications being filed. So it's a small thing. But you know, some of these statistics are of course also difficult to make because you don't know in whose name something is being filed, and so it's maybe not as clear cut as I'm saying it here. But I think overall, that's probably the kind of distribution between individuals on the one hand and corporate applicants on the other.
I mean, it's cool to have international patent protection and building up assets to say, I'm patented in the US, I'm patented here,
Yeah.
I'm patented here, and maybe there is a strategy or plan or a way
Mm,
to get out there. But it sounds interesting to start with, and we feel like, maybe we plant our seeds now, but
yeah.
it's also relative to who we are. Do we have the financial means to
Yeah.
spread across other countries,
Yeah.
or are we just kind of focused on the US, where we protect ourselves and we, maybe we're going into business for
Mm,
ourselves, or we're putting marketing dollars into getting our product recognized, but maybe we're
right.
also looking to build a brand, and that's where the intellectual property
Might
comes
come
in.
in.
Yeah,
Mm,
but
yeah.
the
Yeah. No,
so
I mean, honestly, Brian, I mean, this is a very good point, and I
yeah.
think inventors really need to go back and think about their business model, and you know, where are they today and where would they like to be, and if their interest in business model is not such that they would like to maybe market a product in multiple countries or manufacture it abroad and bring it somewhere else, then you know, by all means the focus on your national home country makes more sense than trying to overstretch yourself and to go, you know, internationally in many countries. One of the difficulties admittedly though is it's sometimes difficult to know now what you want to do in like 5, 10 years time, and unfortunately you need to take certain steps if you want to protect a super cool invention in other places. You need to start doing it early on. I mean, I talked about the 12 month that, you know, the clock is ticking, so you don't really have so much time to wait and see how your business is developing, but you need to actually start. If you at least consider wanting to be protected in other countries, you need to do it relatively early on, maybe at a point where you don't have all the clarity that you would like to have. And maybe in this regard, if I can just add, why I think the PCT is actually an interesting option for also, you know, small companies or individual inventors. When you file a PCT application, you basically have the option of getting a patent later on in all of our contracts in states. So 158, which of course is much too many here, and no one really needs that many. But the cool thing about a PCT is it leaves you the option open to decide 18 months later from filing the PCT where it is that I really need protection. So maybe at the outset, I thought I needed in 10 specific countries. And then 18 months later, as things develop, I realize, well, actually, I only need protection in 2 countries, but that's all possible under the PCT, either to narrow it down or to broaden it. You have that kind of option under the PCT, whereas under the Paris Convention, at 12 months, you need to take a final decision where you continue. And that's often much harder to do than just file a PCT application and then postpone that final decision until a later stage.
Okay, so I can file for PCT.
Mhm.
I kind of have it. I made it within the time frame of the 1 year, within
Yeah.
the 1 year of filing. Not when I have an issued patent, but when I filed is when the clock starts. And
Yeah.
then I'm kind of I kind of put you guys on notice that I'm open to exploring some of the other countries. I met the deadline of within the year, and now you're saying that after that year or part of that year, up to 18 months is when I could decide what countries I would
Yeah.
want to select.
Exactly. So this is how the PCT works. So, like on this slide, you kind of see this light blue yellow phase of 1 year from your initial national, let's call it a provisional application, until you file a PCT, and
Yeah.
then you have the red bar, which is kind of the international phase, and which is 18 months from filing of your PCT. And then at the right, you have the blue bar, which basically is where you need to take the decision where you actually want to continue. And we call it you enter the national phase or stage. And there you then take your PCT application to, I don't know, the office in Brazil, in China, in Japan, et cetera, et cetera.
Okay.
Mm.
We have a couple questions that came
Uh-huh.
in, and this is kind of interesting. Sean mentions if we do not have international protection, can we conduct an international search for our invention?
There are some countries who actually commission that you can ask an international searching authority to do an international search for you, but that's not available in all countries. And I think the usual way to get to an international search report and written opinion would be to file a PCT application from an office. I mean, if you want to do your own, or commission a private search on a more international level, that's of course also something you could consider, but that wouldn't have the same effect or wouldn't come from a particular office, but would be from a private entity.
So, Matthias, we listen to you and we
Mm-hmm.
appreciate you not coming on saying everybody needs to file international and line up and get on and file. We appreciate it
Yeah.
because we have to spend our dollars wisely. We have to make good decisions for us and our family and our product and our business and our brand that we're trying to build, or maybe we're trying to license it to earn royalties and attempting to reach out to companies in particular countries. So we're interested and we say, you know what? I want to go for it. I have the financial means. If somebody does infringe on my IP in that particular country, I'm prepared to hire an attorney and kind of, protect myself. Or maybe I have contacts there that can help me and protect me. Or maybe the companies that I might work with might also help and protect me. So let's say I'm interested. What do I do next? How do I file a PCT? Where do I go? What do I do?
Yeah, I mean that hopefully is relatively straightforward. So I guess you already are familiar with the USPTO where you file your first application. You
Yep.
can actually, as a US national resident, you can go back to the USPTO and file with them a PCT application. They will put on a hat called PCT and they will act what we call as our receiving office for PCT applications. So you could actually just make a copy of what you filed as the US application and then submit it online as a PCT application. There are electronic filing tools available to you, and they should help you guide you through the process of filing it. You don't necessarily need to be represented by an agent at that stage, but that's always a bit of a delicate question. I know it's expensive to hire a patent attorney, but on the other hand, if you mess it up and you filed it, then it's your issue at the end, and having someone who's like a super expert on how to file these applications is of course something that can be extremely helpful. And so we usually advise applicants and inventors to use the services of a well qualified patent attorneys to do this, but you can do it without. And then once you file this PCT application, it will go through a formality check by the USPTO. They will then send a copy to us in Geneva. We will publish the application. You have an optional procedure of asking for preliminary examination. That's not very popular these days anymore. And then at 18 months from filing, you need to then take the decision where to go next, or whether to not go any further. That's of course also something that happens every once in a while. And then basically, once you decided I want to continue with my PCT in the national phase in China and Japan, you then need to send a copy of the application through a local attorney, because there it's very unlikely that.
Whoops. I think we lost him for a moment there. So this is very interesting. You can go on U.S. Patent and Trademark Office website and have the connection to the WIPO, World Intellectual Property Organization,
Mhm.
and part of the PCT. And you can go ahead and put your team there on notice that I'm going to be selecting the countries that I want. So
Yeah.
that's interesting. We go right to uspto.gov website to do that.
Mhm.
My question to you, there's a few questions here, but one
Yeah.
that I'd like to ask you. So, I mean, here's a typical one that we hear quite often. You're in Switzerland, we're here in the US, and hey, I'm an inventor. I feel like as soon as I put my product out there and I tried to manufacture it in China, somebody's going to rip my product off.
Mhm.
What do we do at that point? Like, is it something that the first thing that we should do is protect ourselves in China or Asia, in certain countries?
I guess, again, under the limitation that it's just prohibitively expensive to try to protect yourself everywhere. But if China is really important to you and to your business, maybe yes, the answer would be, after you filed for a US patent, you would also like to file for protection in China. And you could do that, as I just explained, through the PCT. And once you file the PCT, you can actually already tell whoever is potentially infringing your patent rights, hey, I filed for patent protection. So, do it at your own peril to keep infringing mine. Once I have a patent, I'll go after you, and I'll claim back damages to the time, when I filed my PCT. So that's possible, a strategy. But again, having to enforce a patent is also not an easy thing, and it's a costly thing. So I would hope that your strategy maybe wouldn't be from the start trying to, enforce a patent right away, but basically by just showing that you are the future patent right holder of a particular invention, you could keep already quite a number of people from infringing.
Very interesting. I'm going to
Mm.
give you a couple questions here to speed answer if you can.
Mhm.
They're interesting. I really like this one. Thank you, Doc Buddy, for your question. What if the U.S. patent is not granted, or if it's not granted in time? It doesn't worry about if it's granted in time, right? But maybe you can answer this. I'll leave it to you.
Yeah, basically, I mean, patent law is based on the principle of territoriality. So a patent is only valid in a particular country, or what we call jurisdiction. So if you don't get a U.S. patent granted, but you filed a PCT application and then entered the national phase in other countries, these countries are not bound by the decision of the USPTO. they could come. I mean, it can go either way. I must admit. I mean, it can either be more positive for you that you get a patent in Japan on that particular invention, or it might be that you got the U.S. patent and then you're entering Japan and they still don't give you a patent. That's possible. Of course, a lot of offices, because of the sheer workload that they all face, are looking a little more at what other offices might have already done before and might follow. But at least the big offices definitely always search and examine all patent applications according to their standards. And they might not always come to the same conclusion. So, just the fact that you didn't get a US patent doesn't mean you can't get a patent in other countries. And that wasn't probably a speed answer. That was actually already a lengthy one.
It's good. Look, I
Mhm.
know it's after 1 a.m. your time in Switzerland. We very much appreciate you allowing me to pick your brain and to represent the other inventors' questions here. These are
That's
things
totally
that we need
fine.
to know, right?
Yeah.
These are things we need to know. We need to educate
Mhm.
ourselves, empower
Mhm.
ourselves to make better decisions. That's what it's all about. So thank you.
Yeah.
And I'm gonna
Mhm.
hit you with a couple more.
Sure.
As long as you stay up and you don't doze off
I'm,
on
I'm
us.
I'm waking up as we speak. That's
Okay.
good.
Lot of great questions. So where does that leave us? Those of us who have U.S. issued patents, can we still start fresh with a PCT application?
Yeah, that's a very good question. And unfortunately, that is going to be very difficult. So, if you have a US patent granted, I assume it took longer than a year from filing of that initial application. And at that stage, if you then file basically a PCT, you're not going to be able to claim priority anymore under the PCT or the Paris Convention of that earlier filing. And what that means is that anything that was disclosed prior to filing your PCT or subsequent application can be held against you as relevant prior art. And so even if it's your own application, and applications eventually, of course, also get published, these publications would be held against any subsequent filing, even if it's done in your own name, and if you were the inventor on the application that was filed earlier. If it's considered prior art, it can still be held against you. And so that's the problem for those of you who already have a US patent. Then basically on that particular invention, it's very going to be very difficult to still get a patent in other countries. So what you might want to consider is, can I further develop my invention that I already have? And then these further developments, are they maybe, as in, so inventive that I can file a separate application on them? And then you can again have the clock ticking. You file a US first, and then you have 12 months to go international. But
Very
on the original filing, it's going to be very difficult.
Very interesting. You know what's great about this platform is once this is done, it's in our
Mhm.
archive. So for those of you who need to hear something again, or maybe people have missed what we're going through, you'll have a chance to listen to the recording. But
Mhm.
this is powerful stuff. Let's have
Mhm.
one more question here. Two quick questions. So is China first to file?
They're all first to file. I mean,
Yep.
basically, the US was the only one who came in late with first to file. So everyone is first to file, basically.
Okay. I think we started in America's Invent Act in 2016, I think it was.
Yeah.
Yep. All right. Here's another question. On your timeline here that we have up, and I know we have a couple slides. I'm not sure if you want to touch on any of them, but Mike is asking what the 28th and 30th month marks mean in the dark blue. What do they represent on your chart?
So 28 is actually a time limit to establish a preliminary examination report. That's an optional procedure. So you can enter into a dialogue with an examiner at one of the big offices doing surgeon examination work under the PCT. and it's a procedure where you can also amend your application and get to hopefully a fully positive result saying all your claims are novel, inventive, and industrial applicable, and to make it then easier for you to enter national phase. So that's the 28 months. The 30 month is more important. That applies to everyone. This is the time limit within which you need to decide where you would like to enter the national phase and take the steps that are needed to enter the national phase, namely file a translation if need be, if the language is not, English, if English is not accepted, or and file the national filing fees.
Okay. Well, are there any other slides that you wanted to just quickly touch on?
If you just move one left to slide 5, I just like to show this slide. No, the one with the world map.
Okay.
Just because I wanted to give the impression, that the PCT really covers the world. We're very eager to see also Argentina join the PCT. It looks actually very promising at the moment. So hopefully we can paint that gray area in Latin America in the near future also blue. And I think the only other slide I would like to show is the last one, which is slide number 10, um, which is basically a slide where you have information on how to reach us. And sorry, now we're on the 9th slide. Could you go? Yeah, this one here. So this is really, I mean, we have a lot of resources on our website. I didn't have time to show you our website, but if you go to www.wipo.int, you can find the PCT resources website there, and there's tons of information about the PCT. And there's like a little video at the beginning just to explain the PCT procedure very simply, and then you can go deeper and deeper into PCT, and you'll find the resources. If you get lost, give us a call or send us an email. We can guide you. And tell you, what kind of resources you should be looking at. But there's really a lot out there, and so please make use of it. If you want to watch some videos, there's some videos and otherwise written material, so really do use this material, but also reach out to us if something is not clear to you.
It's important for us to figure out our strategies, and in the beginning it might be early, but before you file, even in the US here, you may want to consider thinking about what your plan and strategy might be. And then you file and the clock starts ticking. And then
Yeah.
you maybe file that PCT and the clock starts ticking. And figuring out, am I going to try to license this to a country overseas that I might want to consider? And again, when we're doing this, we're building up our own intellectual property assets, which makes our invention more valuable. And obviously, it becomes even more valuable when you have it, you produce it, you're making it, you're selling it, it builds up, and maybe you're building a brand. So there's a lot of opportunity to extend your invention, your brand overseas. But you also have to remember that you got to protect it, just like you need to protect it here in the US. And those strategies are something that you should consider, whether you're trying to license it or you're trying to manufacture it, or you are manufacturing, to be able to expand your window of opportunity, as I like to say. So, Matthias, you've been in kind of this world intellectual property organization for quite some time. You've worked with businesses, entrepreneurs, startups, inventors. We're at all different stages here, listening and watching to you this evening and your morning in from Switzerland. Give us some final words of advice, your wisdom, your knowledge, to help us to make better decisions, because that's what this is all about. And we so much appreciate you doing what you do for us and spending your time here. Drop some good information for us that we could take away.
Yeah, maybe one thing I would like to point out and remind everyone of, if you think about filing a patent application, it's super important to draft a good application. It's difficult to know how far your application will go, but hopefully you will get a patent granted on it eventually. But if your application from the outset is not really of high quality, then also your patent later on will not be of the highest quality that it could possibly be. So really, there is a need to invest upfront in drafting a good patent application. And if you're not able, unfortunately, to do it maybe yourself, you do need the services of a patent attorney to help you do that. And you know, one of the things that we sometimes see is that applicants quickly file something. They include informal drawings, you know, handwritten little sketches, and that leads to a lot of problems downstream. So really, if at all possible, try to have a complete application with good drawings and you know, something that you think is really solid before you actually file it as a patent application.
Thank you.
That definitely would be a piece of advice I would like to share.
Totally. Thank you so much. So just going through the grapevine, getting in touch with you, and just your openness and willingness to let me pick your brain here kind of on the spot, because I'm kind of hearing it from people and myself with issued patents and wondering about what to do when I'm
Yeah.
considering filing overseas, if I want to, if I don't, how am I going to protect myself? You know, is it going to build up assets for me? So thank you again for doing what you do. I appreciate it. And if there's anything that we could do on our side here, we will keep on inventing and bringing
That
you
is wonderful.
applications so we can
Yes.
keep building our businesses.
Yeah, no, I have like total admiration for the work that so many inventors are doing out there, and it's wonderful to see. And it's not always easy to navigate the patent system, I must admit. And you know, there's a lot of daunting aspects to it, but it's all based on wonderful ideas of people like all of you. So keep at it, please, and make this a better world with your inventions.
Thank you so much. I see here Bob Harrison is still in our back room. Bob, hopefully there you are. So I know that you working with the Small Business Development Center, a division of the Small Business Administration, you work with a lot of inventors and you think about you know, manufacturing and strategy. What did you take away from this meeting tonight?
You know, I've had clients that were given bad advice, as Matthias is mentioning, and didn't file the PCT. They found out later. You know, it's like you want to have professional advice, you know, at each stage. And, you know, I'll recommend to clients that they go over and visit the USPTO satellite office at Smithtown Library to help with research. You know, trying to give them each of the component steps along the way to make sure they checklist and get everything right. So, you know, this knowledge is, you know, it needs to be passed on because you don't want to make mistakes. Like you're saying, if, you know, I found it very interesting what he was saying, that your original patent can be used against you if you don't file. But if you have to generate additional claims that may be valid, it's insightful. And, you know, that's why I wanted to continue listening, because I share this with clients, you know, some caveats. Guys, you know, be careful with your timeline. Make sure you take care of everything.
Thank you
Great.
so much. Thank you, Bob. And we will continue our conversation in the Inventor Smart Community app, in the chats here. We also have where we're doing an after meeting networking. We're going to talk about you, Matthias. I don't know if you want to
Okay.
join. I know it's time for you to
I-
go to sleep, but we're going
I
to.
might at one point, yes, sign off. I
Well,
need to
thank
go
you
to work
again.
tomorrow.
Yep. No, understood.
Yeah.
Thank goodness
Yeah.
it's Friday for you.
Mm.
But we are going to be meeting. We're doing an after meeting networking. We're going to be talking about our experiences, listening to you and sharing what feedback and advice that really stood out. So thank you. And for those of you who are still on, if you can like us, follow us, you'll get notifications of upcoming meetings that we have. you'll like us, for other people to see what you've liked. And we take the time to put this information out there and to provide you the right resources for you to make better decisions. So Matthias, thank you again. Have a great night, great morning, and we hope to see you again soon. Let's keep in touch.
Thank you so much.
Thank you
Lovely to
very
be on
much.
that show. Yes.
Thank you. All right. Well, that's a wrap for March 2026. Wasn't that great? We need to know this. We need this information for us to figure out, do we file international? Do we just stick with USPTO, USA patents? Thank goodness we got this information. So you're welcome to listen to it at any time you want. It'll be in the National Inventor Club YouTube channel, on the other social media channels, in the Inventor Smart Community app. If you're not a subscriber already, it's free. There's premium subscription, but you can go into inventorsmart.app, or you can go to Google Play or Apple App Store and download the Inventor Smart Community app. We have thousands of inventors in there that are networking, social media in there, resources. All this is here to help you. Let's see you soon. Thank you, and we will catch up again until next time. And for those of you who still have a chance to come to Inventor Day in Alexandria, Virginia, at the headquarters of the U.S. Patent and Trademark Office, you can go to inventorday.com. Thank you very much, and we'll see you again soon. Have a great night.